Hi, everyone. Thank you for joining our webinar today. My name is Ida Ashuri. I'm a staff attorney with the Legal Aid Foundation of Los Angeles, and we are joined by Wing Lu today, who will be presenting on trademarks. She is a senior attorney at Nelson Mullins Riley Scarborough LLP, and I'm just going to pass it over to her. Thank you.
Thank you, Ida. My name is Wing Lu. I am an attorney at Nelson Mullins Riley and Scarborough LLP, and I'm very happy today to talk to all of you about a little bit about trademarks. So trademarks are an essential part of your business. They represent your goodwill, your reputation, and they are how people can tell the difference between the products and services that your business offers and what other business offer. But here's the good news. You are here today. You are going to learn about trademarks, and you can go back to your office or to your home office or the coffee shop around the corner that you like to work at and start working on trademarks into your business plan. So what we are going to do here today is to break down the basic facts about trademarks. All right, so we've been talking about trademarks a lot. What really is trademark? Well, the legal definition of a trademark is any word, slogan, symbol, design, color, sound, or device used to distinguish the goods of service or the goods or services of one person from another. And it can also be a combination of all the things we just talked about. But the easiest way to think about it is this: trademark is a brand for goods and services. And before I look into examples, I also want to let you know that not every phrase, word, or picture that appear on a label is a trademark. The critical inquiry of what a trademark is how the destination would be perceived by the public. And we'll go into those later, but I just wanted to, give everyone a heads up. And also, it is very important to know that trademarks are owned by the person or entity that first uses it in commerce. Okay, now let's look at a few examples. Just now we talked about, a trademark can be any word. And the first one we can see is Apple. I think we are all readily familiar with the brand Apple. I'm hoping that when everyone first heard of Apple, it's, the company that makes iPhones, Mac. And the word Apple itself is a trademark because it is associated with the goods, iPhone. And the company that sells, iPhone and Mac, iPad, all those good things. And the next one we are gonna look at is a symbol. Sorry, just making sure. A symbol. So when everyone see a symbol, so right now it's different from a word. Right now in this picture, there's no word in it, and it's just, a picture. And now we understand that you can just do this logo, symbol, as the Nike's trademark. The next one we're gonna look at is color. So in this sense, you can see that it's as opposed to the ones that we just saw, it's black and white. This one is in pink and in blue text, in blue font, and you can see that it means that it can only be used in this way. So it can only be used in the way that this melody symbol is in red, and then sweet and low is in blue. If it was used in other way, it is not claimed. The next thing I want to talk about is a sound. So I am going to share a video. I'm going to share this is what's preload. I hope everyone can see my screen. It's a YouTube page. This is preload. So what we have just heard is the trademark for this NBC news chime. So whenever you hear that sound, you know that, oh, it's NBC News. And last but not least, the example we are going to look at is a device, which also is called a trade dress. And that is the design of the thing, the goods we are selling. So here in this, for example, in this sense, it is very readily apparent to everyone, or it should be, that it's a Coca-Cola bottle. So it gives you an idea that if there is something, a specific design, a 3D design that you like, you actually can trademark it. So as you remember, just to recap, I said that a trademark can be a word, slogan, symbol, design, or a combination of all these things. So pretty much anything can be a trademark or service mark, as long as it identifies the source of goods and service and distinguish them from the goods and service of others. Now we can look at what is not a trademark, the backgrounds. Just now, when we were looking at the Nike logo, the background here, all these white things, the white background is not part of a trademark. And then the marketing content is also not a trademark. The titles of a single literary works, movies, or songs are not trademarked. And it's very important to see the difference. If it's a series of literary works, movies, or songs, it may be. And welcome you to, I'm happy to have a separate discussion offline to talk about this. And I think right now, because we are in digital age, everyone has a website. It is very important. I think everyone would like to know, will have a question as to, when you're opening a business, you have a domain name. And is it the same thing as a trademark? So now we're going to dive into it. A domain name is the wording that people type into the address bar. So for example, here it's uspto.gov, that's the address bar. Or here it's amazon.com in the address bar. And, of a web browser to go onto your site. Or it could be the hyperlink that people click to go onto your site. So now, when you register that domain name, do you use the USPTO to secure that web address? No, right? You register it through one of the domain name registered companies. For example, like GoDaddy. Now, that after you pay a fee, after you choose the domain name you like, and then you go ahead and pay the fee. And then now that means, and then they give you a confirmation page, you go in and then you can design your own web page. Now that means you've secured a web address, sorry. But it does not mean that you have the trademark rights in that wording. In fact, if you register a domain name that includes the trademark of another party, you may have to surrender that domain name. So for example, let's assume that Amazon.com hasn't existed yet. And then there is already a trademark on Amazon.com. And you went ahead, you, not the legal owner of the trademark Amazon.com, went ahead and registered this domain address. You might have to surrender the domain name. So a domain name registration does not equal a trademark registration. Okay, but hang on, you might be thinking, so what about all those companies out there that have .com in their name? So for example, here, we'll continue this example, like Amazon.com. You see, if you go down here, you see that, where my circle is at Amazon.com. And on those both trademarks and domain names, yes, they sometimes are. Domain names and trademarks, they are not mutually exclusive. For example, just because, let me put it this way, just because you have, for example, Amazon.com as your domain name does not mean that you cannot use Amazon.com as your trademark. You just have to go through the procedure to use them in these specific ways to be qualified as, a domain name or a trademark. And a domain name can function as a trademark so long as it is used in a way that identifies the source of particular goods and service. So let's go back and take a look at Amazon.com. I might have gotten ahead of myself earlier. So now you can see that Amazon.com is used as a web address, like here, where my cursor is. And then it is also registered as a mark for an online retail store. So down here where my red circle is, it is used as a source identifier. So where the red circle is here, it identifies all these services and all these goods that can be bought on Amazon. Okay, just now we talked about domain name. And right now, another big part of your business plan would be your business name. And there is also a difference between a trademark and a business name. A business name is just that, it is simply the name under which you do business in a particular state or jurisdiction. If your state requires your business name is registered with your specific state, as I'm sure most of you have done so already. However, a business name registration with your state does not grant you trademark right. It merely means that a particular state allows you to do business under that name. So for example, Apple is a company that is in the business of, among other things, selling iPhones. And it went ahead and go to California Secretary of State to register its company name, Apple Corporation, I believe. Oh, LLC, actually, sorry. That simply means that California allows Apple to do business in California. It does not mean that simply because you register your business name with California Secretary of State that you automatically got a trademark. But now you're thinking, okay, just now we just used Apple as an example, as a word mark. So can a business name also be a trademark? Of course. So just like domain name, it all depends on how you use it. So if you use your business name to identify the source of your goods and services and distinguish them from the other goods and services of another, it is a trademark. So To enjoy the nationwide rights offered by a federal trademark registration, you must file an application and receive a registration from the USPTO, United States Patent and Trademark Office. Individual states also offer to register trademarks, but any protection granted is limited to that state. So again, like if you want to do business both in California, Arizona, and you are also hoping to do business in New York State, I would strongly suggest you to file an application and receive a registration with the United States Patent and Trademark Office. Otherwise, if you simply apply for a trademark registration in California, that registration is only good in California, not in other states. So to recap, just because you have a domain name and a business name, it does not mean that you have a trademark registration, okay? You have to use those names as trademarks in order for them to become trademarks. To obtain the benefits of a federal trademark registration, you have to make sure that you apply for and get a registration with the United States Patent and Trademark Office. I know I gave everyone a lot of information just now, and I'm trying to make sure everything is clear. This is the way it all breaks down. Trademarks are brands. Domain names are web addresses. And business names are just the name, just the entity name under which you have permission to do business in a particular state. Now, trademarks are handled by the United States Patent and Trademark Office. Domain names are handled by domain name registrars, for example, GoDaddy. And business names, you want to check with your Secretary of State's website, and then you can get more information there. Okay, I'm hoping that everyone is with me so far. And we had a little bit of idea of what trademarks are. And we need to know why it is important to register them with the United States Patent and Trademark Office. And a lot of people ask, is federal registration of my trademark required? The quick answer is no, but it will enhance your right. So here, in the United States, trademark rights are created through the use of your mark in commerce and not through registration. These use-based rights are known as common law rights. The rights, however, are limited, open to a particular geographic area. That means it might be hard for you to enforce those rights outside of the limited scope, and it might be hard for other people to know about your rights. So federal registrations is going to greatly enhance your rights. Specifically, registering your mark is going to give you the following benefits. First of all, it creates a legal presumption that you are the owner of the mark. Otherwise, it is something that you are going to have to prove if you wanted to enforce your registration, either in or out of court. And that's what we call a constructive notice to the public of the registrant's ownership of the right. And then second, it gives you a legal presumption of exclusive right to use your mark nationwide with the goods and services that are identified in your registration. Now that is in contrast to a state trademark registration, which only gives rights within the borders of a particular state. So federal registration is going to give you a presumption of rights throughout the entire United States and its territories. It puts the public on notice that you are the owner of the mark. If there is a question as to who owns the mark, it can be looked up on the USPTO online database, which we can get to in a little bit. And then there is also the benefits. that being listed in the United States Patent and Trademark Office database means that others considering a potential mark can find your mark when they search the database to see if their mark is available. So going back to the example of Apple, if for some reason tomorrow, my friend who has never heard of the company Apple decided to, I'm going to start a company that is in the business of designing and selling phone, then he or she may go to United States Patent and Trademark Office database and look up whether someone has already been using a mark called Apple in a similar way. And lo and behold, there it is. So that is the benefit. Because the existence of your mark in the database can help others avoiding selecting a mark that is too similar to yours. In addition, the United States Patent and Trademark Office relies on the same database for its own search, and it will find your mark whenever it is examining other people's application. So then the United States and Patent and Trademark Office will then cite your registration against a confusingly similar mark in a later file application, and then preventing a potential conflicting mark from registering. So it will be protecting your right. Because we do not want someone to have a mark that is very similar to ours, and also used in the same manner. If I'm selling phones, I would not want other people to also be selling phones under a very similar trademark. Then people wouldn't know that whether it is me that's actually selling the phone or someone else. And then the federal trademark registration also gives you the ability to record your trademark with the U.S. Customs and Border Protection. That agency will use your trademark registration to prevent importation of infringing or counterfeit foreign goods. In addition to all those, you have the right to bring a legal action concerning the registered mark in a federal court. And then later, if you wanted to expand your business and conduct business in a foreign country, you have the ability to use your U.S. trademark registration as a basis for applying for a trademark registration in many, many foreign countries. It is a great benefit when your business takes off and you become a global phenomenon, okay? And last but not least, a federal trademark registration means that you have the right to use the coveted R in the circle symbol with your mark. And that is something you cannot do unless your mark is federally registered. Even if you apply for it, you still cannot use the mark, cannot use the R with the circle. You have to receive the official registration from the Patent and Trademark Office in order to put the R in the circle symbol on the right side of your mark. And that symbol indicates that you have federally registered your trademark with the United States Patent and Trademark Office. It puts the public on notice that your mark is registered and you have the nation rights in it. Now, it can serve to cut off the rights of others who might have started using the same mark after you apply to register your mark. So as you can see, registration provides a lot of benefits, and it probably explains why the USPTO, U.S. Patent and Trademark Office, has registered many millions of trademarks over the years. Okay, so let's see where we are. You've decided that your business needs to protect its brand. So you've determined that what you need is a trademark registration. And you've determined that pursuing the benefits of a federal trademark registration is the right investment for your business. The question then becomes, okay, so what is your trademark? Do you have one already? Is that one you like to use? Or do you have no idea at all and you are open to any good ideas that come along? Well, before you apply for federal registration, it is important to understand that not everything that you want to register as a trademark can be registered. The USPTO examines every application for compliance with federal laws and rules, and if the application does not comply, the office will send a refusal letter known as office action. Now, in some cases, it's possible to overcome the refusal, but not always. One of the things we want to consider when we are trying to select a mark to apply, we want to know what is the strength of the mark. So here we have fanciful, arbitrary, suggestive, descriptive, and generic. These are all the possibilities that a mark can be. A mark can be fanciful, a mark can be arbitrary, a mark can be suggestive, descriptive, and generic. And here's more examples for it. So Google. This is a mark that is fanciful because it does not mean anything. And then we have Blackbow, we have Microsoft, and then we have the University of South Carolina, and then we have aspirin. All these are examples that will fit in this description, and I will leave it as your homework to figure out which one is which. Maybe we can figure that out after this presentation. So now we can go into what is fanciful or arbitrary. So a fanciful or arbitrary mark is inherently distinctive and immediately protected. What is a fanciful mark? A fanciful mark, like I said, it doesn't mean anything. It just, like a random combination of words. And what is arbitrary? It is similar to fanciful. It just, it does not. So for example, Apple, I'm keep coming back to this example. So for example, Apple and, phone design, cell phone design, it is arbitrary because it does not describe it. The connection between the word Apple and phone or, computers is very, very remote. So that is an example of an arbitrary mark. Once the business becomes so big, there is a danger of generic side. And that means that, for example, Kleenex is a trademark for tissue. And right now, everyone, when we say, oh, I want a piece of tissue, we would just say we want some Kleenex. And that is what I mean by, it will become generic. And the next thing we have, suggestive versus descriptive. Just because something is suggestive does not mean that it's descriptive. These two things are distinguishable. So descriptive means that a mark that immediately conveys the knowledge of a characteristic or the quality of the goods or service. Suggestive means marks are those that, when applied to the goods or service at issue, require imagination, thought, or perception to reach a conclusion as to the nature of the goods or service. Therefore, a suggestive term differs from a descriptive term, which immediately tells you what the goods or service is about. We'll go into a few examples. If a mark that is, descriptive, it can be the product configuration in a trade dress. It can be laudatory terms, it can be geographic terms. So for example, I'm trying to say Los Angeles Legal Service. That is, a geographic term because we limit it to Los Angeles. And then there is also the model and grade destination. There is also personal names. These can, for example, dismiss. That is description. Going back to, suggestive versus descriptive. These can be, if you are opening a cake shop, if you are selling cakes, if your mark says, sweet and delicious, that is descriptive because you are describing the characteristic of your goods, of your cake. And in trademark, we also have secondary meaning. You want a mark that's you want to apply that's suggestive and descriptive. A lot of the time, the examiner from the trademark office will want to know the secondary meaning of your trademark, which will require you to provide evidence of prior registrations, amount spent on marketing, any sales success, or any unsolicited media attention. A long-term use in commerce, which means it should be more than 5 years, and evidence of copying. Evidence of copying means some other people was trying to copy your mark, and that's why right now we really need to get a federal registration in order to get protection. So now let's talk about the trademark application process. There are two bases to apply for a trademark. One is intent to use, one is actual use. If you have not yet used the mark in commerce, you can apply the mark on the basis of intent to use. If you are already using the mark in commerce and you decided that it's a good time to apply for a federal trademark registration, then you will be applying it under actual use basis. A trademark is something that should be used in commerce. So after we apply for a trademark application, whether it's on the basis of intent to use or actual use, we will still need to provide documents to support your use in commerce. So that's why it's intent to use, which means, you have to use it within a certain time. And you can get extension because the trademark office understand that sometimes, you have a good idea for a trademark name and a business, but you sometimes need product development in order to get the product onto the market. So after you apply for the trademark, you can get an extension for up to 3 years to submit the use evidence, the evidence of you using the mark in the way that you identify in your application, and with a fee. And the requirements for a trademark application are, the mark that you intend to apply for, the description of the mark. It will be very easy if it's just the text. If it's you want to do a logo, a design, you will have to describe your design. And then there's the date of use, which what I was trying to convey. If you apply on a actual use basis, it is easy. You just have to submit, the first day of actual use. If you are intending to use it, you may, ask for more time, up to 3 years. With a fee to submit evidence of using it, of the first day you use it. And drawings refer to the non-text mark, so like or a design mark. And then specimen means, evidence of using. It can be, a website. For example, going back to, it's not what we have seen here using the mark Amazon.com in the way that it was applied for. So this screenshot will be can be a specimen of the trademark Amazon.com. And then there is a fee associated with it. And I think that's a good segue into what I will show you next. You're in the business, you want to know how much things cost. So for a trademark application, the fee has to do with the class of goods. So the class of goods, we have what we call international classes. So depends on the number of goods you use, the fee is different. Now I'm going to show you a screen from the USPTO website. So T plus is what, and T standard, these are the application portal. You use this portal to apply for the trademark. And if you go through T plus portal, it will be 250 per class of goods or services. And if it goes through, T standard, it will be 350 per class of goods and services. And as we can see here, only one mark may be filed per application. If you have multiple marks, they require separate applications, each with its own filing fee. And you must pay for each class of goods and services in the application. So for example, if an application is for a mark, but the mark is using on goods in 2 different classes, such as computer software in class 9, t-shirt in class 25, then a filing fee for the 2 classes is required before the application is approved. So I understand that this is all new concept to everyone. Just now we saw computer software was in class 9 and then t-shirt is in class 25. So there is a way to find out which number of the class you want. What you would do is you will go to the United States and Patent and Trademark Office. And then there is a manual for international classes. At this point, when you have a business plan, I'm sure you have an idea of what you want to be selling or what services you want to be providing. So how you would use the United States Patent and Trademark Office search database, you just simply type what services or goods you are interested in, and then they will generate which class you want to apply under. And just now we talked about the cost relating to international classes. It is 250 and 230, depends on which route you use. And then, on the same website, we will also have, tools and tips for, determining classification of goods and services. It's also important to, consult your attorney in order to, get a better idea of what you want. In the realm of international classes, we have classes for service mark. We have classes for products and goods. So you may want to know that if you are in the business of selling, for example, a t-shirt, you may also want to apply for the service of, marketing the t-shirt. Because what happened is that you will be selling a t-shirt under the name, let's say, Urban Outfitter. And then there is another business trying to sell shirt under Urban Outfitter. You will have a much easier time to prove that you are already marketing your, Urban Outfitter t-shirts. So that's why, it's important to think through, what you want to do and what classes of goods or service you want to apply for in a federal registration. I'm going to skip some of these because of the time constraint, but I do want to know that it is possible to abandon your trademark even after registration. That will happen if you stop using a mark with the intent not to resume. What does it mean by intent not to resume? Obviously, it's on a subjective standard. But if after 3 years you still have not used it, it is presumed that you do not have an intent to resume the use, the use of your trademark. Another factor is that you fail to police. If you see that all other people are using your mark and you stop and you just do not do anything about it, that's what we call failure to police. And I am going to leave it up to questions for now.
I actually had a question, Wing, if you wouldn't mind answering. Could you describe what you mean by use in commerce?
Using commerce is that, your use in the market. You cannot be like, oh, we are friends. I have a trademark for a t-shirt and I'm giving you a t-shirt under the trademark name, under my trademark name. That itself is not using commerce. There has to be some marketing effort. So for example, I am selling the t-shirt under this trademark and I market it. I have, I made a website. I have sales flyers about it. And then I charge people money for it. And, that is what we call using commerce. If it's just like a friend giving another friend, a gift for free, that would not be qualified as using commerce, even though you think you're using the trademark.
I don't see any other questions at this time. Thank you, Wing. I do want to inform everybody if they would like to have pro bono assistance as well for their small business, they can go to lalegalhelp.org. And we do have a program with LAFLA that helps small businesses. And that is the website you would go to in order to apply. And we will make this PowerPoint available on our website, as well as a video of this webinar along with the interpretation. But we can also see if there's any more questions in the Q&A or chat.
All right. Okay, well, thanks everyone for tuning in. And yes, please contact Legal Aid Foundation if you have any questions. And I hope you have a good day. Thank you.